Hi, I'm Anna,
I'm Emily.
and today we will be explaining the purposes of domestic violence courts. Victims of domestic violence are less likely to report crimes committed against them than victims of other types of violence. Underreporting occurs for a variety of reasons. For example, complexity and intimacy of the relationship between the victim and the perpetrator could play a part in the unwillingness of reporting on the victim's part. It is therefore imperative that when victims do come forward to report domestic violence, the justice system responds meaningfully. Governments have committed themselves to improving the criminal justice system's ability to respond, and so the Specialist Domestic Violence Courts, SDVCs, were created. The first SDVC was opened in Leeds in 1999. By 2008, there were 64, by 2010, there were 141, and by December 2013, there were 138 SDVCs across the country.
SDVCs emerged as a problem-solving court in the 1980s and 1990s in response to frustrations among victims, judges, and attorneys who dealt with an insufficient justice system failing domestic violence victims. SDVCs were introduced for the convenience of domestic violence victims to assist them in coming forward and/or accessing the criminal justice system, to improve victims' experience of the court process, and also to increase the number and speed of convictions of domestic violence.
When the Crown Prosecution Service, the CPS, has reached a decision to prosecute in a domestic violence case, the case is brought into the court where remands, convictions, and sentences are decided. SDVCs are specially adapted magistrates' court hearings and are particularly inspired by the relatively successful US model of problem-solving domestic violence courts. SDVCs in England and Wales include some elements of the US model. Such elements include independent domestic violence advocates who support the victim, as well as additional training for magistrates and court staff.
Domestic violence courts exist to tackle topics that general courts find difficult to deal with fairly and easily. They may require specialized knowledge or rules to handle cases, and in the context of domestic violence, SDVCs have a problem-solving focus where an emphasis is placed upon therapeutic resolutions. This is substantially different from the defendant versus claimant situation that we are used to hearing in normal criminal courts. Often a lot of emotions are involved. A majority of the time the victim is still in love with the perpetrator. However, this would be inevitably different from situations whereby a victim is harmed by a stranger. Problem-solving focusing attempts to solve the problem by concentrating on underlying issues. This approach often relies on rehabilitation to accomplish its task.
SDVCs have a number of purposes achieved through their effective practice features. Firstly, SDVCs aim to improve the judiciary's responsiveness to domestic violence cases, as well as improve the effectiveness of the response. More comprehensive relief is provided for victims at an earlier stage of the judicial process.
Speedy access is available for victims to multi-agency support and information services. The speedy referral of victims refers to those assessed as most vulnerable to specialist caseworker support. These services are provided following the arrest of the perpetrator, whereby tailored support and advice for victims are available from Independent Domestic Violence Advisors, IDVAs. IDVAs were consistently praised for ensuring that the courts kept a focus on domestic violence, and evidence gathered by the Centre for Justice Innovation further suggests that the justice system directly benefits from the work of IDVAs. Coordinated Action Against Domestic Abuse 2011-2012 data suggests that in cases where IDVAs have been engaged with victims and a charge has been made, 86% of victims' cases proceeded to prosecution.
Secondly, SDVCs aim to incorporate specialised case processing into the system. Victims are kept informed about and engaged in case progress, so they are always fully aware of what is going on, which would be reassuring for the victim. Thirdly, SDVCs aim to improve victim safety with the use of a dedicated and safe courthouse. There is a danger that perpetrators will use the opportunity provided by the court appearance to intimidate or harm the victim. The courthouse used special measures to improve the safety and experience of victims. Such measures include screened witness boxes, live TV link for witness testimony, separate entrances, separate exits, and separate waiting rooms for victims and perpetrators. This is to ensure that victims do not come into contact or into account with the perpetrator. Victims and witnesses are also given the opportunity to have pre-court visits organised through the witness service. This allows them to see what happens during a trial, and so that they can also request safety measures for the day. The judges and court officers are specially trained so they have a good awareness of the key features around domestic violence. This way, judges are sensitive to the needs of victims. This is crucial because victims often have low self-esteem due to the abuse they've received. It is likely that it is indoctrinated in them that their abuser holds power and authority over them. Since specialised judges understand the dynamic of domestic violence, they would try to take power away from the abuser by imposing their control over the situation. This improves responses to domestic violence cases, as normally many victims become overwhelmed by the situation and withdraw the charges. This links back to the problem of underreporting mentioned before.
Fourthly, another purpose of domestic violence courts is the incorporation of a stronger focus on rehabilitation of offenders and deterrence of repeat offences. The sentences handed down by the specialist magistrates at this court are intended to be rehabilitative. In exchange for a non-custodial sentence, perpetrators of domestic violence are expected to attend training sessions aimed at addressing their violent behaviour in an attempt to control it. Victims of domestic violence are more likely to have been victimised repeatedly than in any other type of crime. Proponents note that a judge's greater familiarity with a particular case's history will discourage leniency for repeat offenders and will increase compliance with court orders. Having a more detailed background about the case may help them be more sensitive to the needs of the victim, and the fact that fewer individuals will deal with these cases can help deter future violence, because offenders will expect increasing penalties and greater accountability. When offenders are less likely to encounter the same judge, the percentage rate of repeat domestic violence offences is typically around 20%.
Lastly, another purpose of SDVCs is to relieve pressure on general courts. By removing domestic violence cases that tend to be time-consuming, this frees up the resources of the lower courts where many of the cases would normally be tried. This is useful as lower courts suffer from problems of inadequate financing and inadequate facilities. On the flip side, one could argue that specialist courts take away money and resources from the general court system, placing greater stress on them. There are clear signs of success evidenced by a review of 10 SDVCs conducted between October 2006 and March 2007 by the CPS, which found they had achieved successful prosecutions in more than 70% of cases. As can be seen by the graph made by the Centre for Justice Innovation, the number of convictions for domestic violence has risen by 77% from 2005 to 2006 to 2012 to 2013. However, there has been a significant decline in convictions from 59,000 in 2010 to 2011 to 52,500 in 2012 to 13. This marks an 11% decline. Nevertheless, there is still clearly a significant improvement in the number of convictions for domestic violence.
As Chart 5 sets out, the quantity of reports of domestic violence to the police has also gone up by 37% over the same period. This trend is potentially encouraging as domestic violence remains an underreported crime. This rise hopefully suggests that more victims feel able to come forward and report the crime, although it could also mark an increase in incidents. When you look at the rise in reporting alongside the rise in successful prosecutions, the last 2 years of decreasing convictions is a worrying trend. By indexing the two data series in Chart 6, it can be seen that between 2007, 2008, and 2010 and 2011, prosecutions for domestic violence increased at a greater rate than the increase in the number of reported incidents. This trend starts reversing in 2011 to 2012, and it is anticipated that this downward trend will continue due to the fall in convictions recorded in 2012 to 2013.
One of the main criticisms of SDVCs is that judges in specialist courts may be less impartial. This is because of their expertise and knowledge about the case, which could potentially lead them to being sympathetic to victims. The strong emotions involved may cloud the judge's judgment.
The effectiveness of the court's response is questioned. The availability of victim services such as effective counselling, referral for long-term support, and provision of emergency accommodation varies regionally. Despite the apparent speedy referral of victims to specialist support, evidence from observations and from survey responses showed that in some areas there was a lack of communication between statutory agencies and IDVAs. A significant minority thought special measures were provided ineffectively. Among responses, there was evidence that the process for applying for special measures was seen as requiring far too much effort and that special measures ought to be available as an opt-out rather than opt-in basis.
Moreover, SDVCs lack one of the most important elements of an effective domestic violence court, which is the judiciary's power to monitor perpetrators during a sentence, as this could help keep victims safer and hold perpetrators accountable for their actions. There has also been expressed concerns that some of the principles of SDVCs are not being delivered consistently in some courts. Due to regional variation, some courts may not have specialist prosecutors or judges, and the level of support available can vary. SDVCs also depend on partnership work between agencies and the voluntary sector. The continuance of the partnership work may be difficult due to the increasing strain on public service budgets. Consequently, it is unclear how many SDVCs may have been effectively closed since 2013. In order to deliver effective responses to domestic violence cases, court staff, probation, prosecutors, and sentencers should be specially trained and should develop strong working relationships with their independent domestic violence advisors, IDVAs. The job of IDVAs is to form solutions to protect safety of victims and their children if necessary at high risk of harm from the perpetrator. Unfortunately, according to evidence from research conducted by the Centre for Justice Innovation, the IDVAs surveyed believed that the CPS and magistrates were not trained well enough, and also believed that the availability of experienced and trained court staff had degraded over the last 12 months. SDVCs should be re-accredited. To accredit means to give authority to someone or something when recognised standards have been met. The Ministry of Justice, the Home Office and the CPS should work with the voluntary sector and service provision organisations to review and re-accredit SDVCs in order to ensure they are delivering effective practice, since its efficiency in its response to domestic violence cases have been criticised. Furthermore, sentencer supervision, which is high-quality court monitoring of perpetrators, should be introduced. The court's role post-sentence is actually very important, as research suggests that where courts are proactive in regularly monitoring the compliance of perpetrators, this reduces the chance of perpetrators reoffending and increases victims' feelings of safety. This would resolve the recent complaints made by judges who believe that they do not have the sufficient resources to prevent future reoffending by the perpetrator. Thus, experiments with the sentencer supervision of perpetrators should be conducted to see if it really does enhance victim safety and reduce reoffending by the perpetrator.
SDVCs are an important feature of the justice system, as there needs to be specialised courts to domestic violence cases due to their nature compared to criminal cases. And it is clear that there have been improvements for victims of domestic violence since the introduction of SDVCs. While there has been a general strain on public services, resources, and court closures, there is evidence of strong support for the concept of SDVCs, not only from the governments, but from our own communities. Nonetheless, developing the effectiveness of SDVCs has been difficult in the present day. It continues to be a concern that the number of convictions has now dipped in 2 successive years, especially given that the reporting of domestic violence has continued to increase. The SDVCs have not always been able to deliver key components of the model. The availability and quality of trained staff is seen as a problem by IDVAs in a number of SDVCs. Performance has also deteriorated in the past year due to the pressures placed on partners working in SDVCs. Collective commitment from the government, practice organisations, and charities should continue to support SDVCs in order to ensure that STVCs are maintained.